In a nation where the rule of law is a cornerstone of democracy, one institution stands tall: the Supreme Court of Kenya. For 12 years, as an arbiter of justice, it has respected, upheld, and protected the Constitution. Join us as we journey through a decade of defining moments. The Supreme Court was born from the aspirations of a nation. It was a bold step towards a new era of justice and accountability. The establishment of the court was intricately tied to Kenya's constitutional rebirth. It was created to safeguard the transformative promises of the Constitution by being a final arbiter of legal issues.
The Supreme Court was established after the promulgation of the Constitution of Kenya 2010, following a clamor by Kenyans that they required an apex court that could settle with finality certain complex matters with expediency, like the presidential election dispute. The Supreme Court has also settled many issues involving the application and interpretation of the Constitution, which is an original mandate given to the Supreme Court.
There were so many challenges in terms of democratic governance, which started, of course, with the Independence Constitution, the 1964 Constitution, which then was amended, and with the Constitution amendment starting from 1991. The introduction of multi-party. There were amendments in 1997 to open the space for electoral democracy. A failed referendum in 2005 when Kenyans said no to a new constitution, to the elections of 2007. And as a result of that, they created what they call the Agenda 4. And one of the agendas was to create a new constitutional dispensation.
The entry of the Constitution 2010 of Kenya came with a fundamental shift in the constitutional architecture of the country. The Supreme Court of Kenya, as the apex court, was established to inject new judicial philosophy and develop indigenous jurisprudence that aligns with the new constitutional provisions.
I was lucky to have been appointed a member of the Constitutional Review Commission of Kenya. Kenyans were particularly concerned about the judiciary at the time, that the Court of Appeal as a final court at the time was not sufficiently capacitated to handle matters of national importance with finality to the satisfaction of Kenyans. They also said they want a court which would be above the Court of Appeal at the time, a court that would then have the confidence of Kenyans that when you've exhausted the legal mechanism, you'll receive justice at the highest level, which will be the Supreme Court. So that was the history and the reason why the Supreme Court was created.
The Constitution under Article 163(1) established the Supreme Court as the apex court in Kenya with the following mandate: A. Exclusive and original jurisdiction to hear and determine presidential election petitions. B. Hear appeals from the Court of Appeal on both matters of general public importance and interpretation and application of the Constitution. C. Hear appeals by judges from tribunals formed for their removal from office. D. Render advisory opinions. And E. Determine the validity of declarations of a state of emergency. Following a competitive and open recruitment process by the Judicial Service Commission, the inaugural bench of 7 judges of the Supreme Court was appointed on 16th of June 2011 by His Excellency President Mwai Kibaki and assumed office on 26th of August 2011. Over the years, the composition of the bench has undergone changes. Once Chief Justice Dr. Mutunga's term in office came to an end, Chief Justice David Maraga was appointed thereafter in 2016 and served until 2021.
I, David Kenani Maraga.
Also, following the exit of Deputy Chief Justice Dr. Nancy Barasa, Lady Justice Kalpana Rawal was appointed in 2013 and served until 2016.
I, Martha Karambu Kome,
The current bench is under the leadership of the Chief Justice Martha K. Koome, who was appointed in 2021.
The judiciary required massive transformation of its operations for it to meet the tenets of that constitution. My predecessor, Dr. Will Mutunga, started that with the blueprint of judiciary transformation framework, and I laid the basis. When I took over, I built on what he had started, enhancing service delivery and ensuring that parties are able to access justice freely.
I think we are the best performing court. We are almost real time. When you file a matter, especially an application, it will be handled and disposed of within 3 months. The petition of appeal will be disposed almost in a year's time.
Because of our refined jurisdiction, since 2011, when we first sat, there's been filed a total number of 680 cases of all natures, applications, petitions, and advisory opinion. As we speak today, we have settled them except for 41.
At the beginning, we didn't have advanced technology, ICT, that we have now. Everything was manual. Now we do even virtual hearings, and we are able to dispose of cases quite fast.
The court has done a great work. The foundation that was laid by the pioneer judges and that continues to be built by the current judges ought to continue. The kind of jurisprudence that we are churning out that are cited across the world ought to continue.
Over the years, the Supreme Court has delivered landmark judgments, developing a rich and indigenous body of jurisprudence that reflects the spirit of the Constitution while addressing the evolving needs and demands of the Kenyan society.
In the revenue allocation case, the Supreme Court clarified the role of the National Assembly. The Supreme Court clarified the role of the Senate. The Supreme Court clarified the role of county governments.
BBI report itatekeleza mikakati ya kuboresha maisha ya Wakenya wote.
The Building Bridges Initiative case to amend the Constitution was very emotive. The country was divided. It had brought a lot of tension, and the Supreme Court was able to determine it with the finality.
The Supreme Court's decisions, for instance, in the areas of environment and land have been clear. I refer to decisions such as Mitubel and Kenya Airports Authority, for instance.
The 2017 Supreme Court decision made it very clear that unless the electoral process was done in accordance with the Constitution, the court would set it aside.
We have made decisions on the removal of judges, separation of powers when it comes to advisory opinion that we've given.
We made a landmark decision in criminal law where we declared the death penalty, the mandatory death penalty, to be unconstitutional, relating to family law. Many people call the come we stay a marriage, when in actual fact it is not. You're not married, you have purchased this property together, you are no longer together. What then happens? So it was a lacuna in the law which the Supreme Court has settled.
There is something called collegiality. Collegiality means aspect of each one of us contributing as much as they must to the determination of the case, and the rest of us respecting each other's ideas and the fact that the decision has to be the decision of the court, not of one, not even of the 5, but of the 7.
The journey has not been without its challenges. But through it all, the Supreme Court has remained steadfast in its commitment to justice. It has faced criticism, withstood pressure, and emerged stronger.
And the first challenge is the number of judges in the court. A few years back, the court faced a challenge. Judges had retired. One judge was available to sit, so suddenly we had 4 judges. That is exceedingly dangerous. So we have made representations that the number of judges should be increased at the very least to 9, or we suggested 11, with a quorum of 5, so that in whatever circumstance, the court will always have 5 judges to sit.
Then we were swamped with a bewildering array of legal issues, of constitutional issues. What would be the appropriate date to hold the first general elections under the 2010 Constitution, for example?
The biggest challenge we face today is unwarranted criticism. We do not get positive criticism that can help us develop. All we get is our insults in social media, in the mainstream media, and that's something that can weigh down on human beings.
The time for hearing is so short, the evidence voluminous, and then there's preparing submissions, and finally for the judges to retreat. Sometimes we retreat only for 2 days. We should have at least 60 days, minimum in my view, 45 days.
The Supreme Court has no home, and it is our priority to build a Supreme Court. We are seated in an old building, the museum, where we have no space. So we have plans to build a Supreme Court of Kenya.
The court strives for excellence in its case management, from scheduling hearings, settling timelines, managing case documents, facilitating communication between parties, and ensuring that cases move through the system in a timely manner. The court has also harnessed technology to improve on its efficiency and effectiveness.
All courts go digital. The e-filing system, now available countrywide.
The Supreme Court is basically a virtual court. We do not have physical hearings, so we have a virtual court for all the hearings, unless there is any need to have a physical court. And I stated that the physical court ordinarily is during the presidential election petition. The rest of the matters, and virtually anybody can log in from any part of this country. We have a virtual customer care desk. You do not have to come to Nairobi or any of the sub-registries to get information about your matter. You can virtually be assisted by the staff from the registry. The e-filing, you do not have to come to Nairobi or to any of the registries to do your filings. You can virtually file them through the e-filing or the CTS system that is in operation within the courts.
To ensure that cases, once filed, the law gives us 90 days within which to settle them. And therefore, my responsibility is to ensure that the cases are settled. If not within the 90 days, and thank God we have settled many long before the 90 days, then it must not go beyond 90 days by too long.
You know, I tell people who are from outside of our country about the extent to which the judiciary has embraced technology. And they don't believe me until they become consumers of justice. And they're like, Chuti, this doesn't even happen where we come from, you know, and that's supposed to be the developed world. So I can tell you, the entire judiciary technologically is doing so very well.
Yesterday I saw a post, a forum at which I believe Justice Mohammed Ibrahim will be speaking. I think we would like to see more of those. I think we would like to see more visibility of judges of the Supreme Court within an academic setting in which they speak about matters of public interest.
The judiciary badly requires financial autonomy. So it provided in Article 173 for a judiciary fund to be established to enable the judiciary to run its affairs.
Everyone around us, tell us what we've done right and what we've done wrong and what we can do better.
The judiciary is one of the 3 arms of government, not the 3rd arm. There's need for the other 2 arms to consider the judiciary as part of the government.
We have not brought on board the general public. Courts will play their role, but theirs will be limited. To what extent can a Kenyan, for example, feel that they are part and parcel of what is happening?
As we celebrate these 12 years of this court, give us feedback. We shall introspect, and we can only make this court better and make our judiciary better for the sake of the great people of the Republic of Kenya.
Kenyans have been very supportive. As one of the levels of court in the judiciary, it has strengthened the independence, the judiciary. So Kenyans should know that the judiciary is there for them, Supreme Court is there for them. Our doors are open, and with God's blessing and support of all Kenyans, we would like to continue discharging our constitutional obligations so that Kenyans enjoy their basic human rights and the rule of law.
It is that one court where you know you have one option, which is to get it right, to do it right, to stabilize the country.
There is a lot of hope of even getting Kenyans embrace all these principles that are enunciated in the Constitution. The principles of good governance, the principles of respect for one another, the principles of non-discrimination, because these are all principles that are being interpreted by the Supreme Court. And we hope that through those judicial pronouncements, we can make some of these principles a way of life, a culture of respect of the Constitution, a culture of respect of the rule of law, a culture of respect for human rights. That is what we are looking for in the future.
12 years is just the beginning. The Supreme Court of Kenya continues to respond to the changing needs of the nation. As it enters its next chapter, Kenya can be confident that it will remain the guardian of the Constitution and the champion of justice for all.